Hey guys, lately we've been talking about judicial review and the power of the Supreme Court, and how when the Supreme Court makes a decision, it sets what we call the precedence of how all lower courts are going to have to rule going forward in our country. So that's ultimately uh, a very powerful uh, position that the Supreme Court has in our daily lives. Okay, so keep that in mind as we go through the information on the Supreme Court and the judicial branch. I've always said it's kind of like, I feel like it's the forgotten branch because most students know about the executive branch and the president. Most students know about the Congress and the legislative branch, the lawmaking body. But when it comes to the judicial branch, a lot of times we're kind of like, who cares about that one? All right. Well, we should care because they ultimately rule on cases that impact our constitutional rights. And then ultimately, when they do make those rulings, like I said, it sets the precedence of how other courts have to rule on similar cases, and then sets the standard for your rights and mine. Okay, so we're going to go through 10 Supreme Court cases that every teen should know. These are court cases that had to do with teenagers' rights in school, which is fitting for you guys since you're all high schoolers. I'm going to go through the first three with you, and as I go through it, you can go ahead and flip back and forth to the worksheet I posted, where you have to put the date of the case, the amendment, and the right in question. So which amendment number, and then what's the right. So First Amendment speech, Second Amendment right to bear arms, whatever it is. And then questions 1 and 2 are kind of a little more open-ended, just explanation. So what was involved in the case, with this case. And then the second question for each one will be explain the Supreme Court ruling and the precedent that this case created. So that word precedent is the key word I want to keep going back to. Okay, so like I said, I'm going to go through the first three here in the video. You can follow along and fill out the worksheet as we go, and then you can go ahead and do the other 7 on your own. Okay, so looking at the first case, it's Tinker versus Des Moines. So the date was 1969. So some of these cases are quite a bit older, a long time ago, but they're still in our schools today as far as how they impact our schools today, I should say. Okay, so the issue is freedom of speech at school. A lot of students are interested in freedom of speech. The bottom line is you have the right to express yourself up to a point. So what is that point? Okay, as a high schooler, you can say what you want up to a certain point, and at that point, your rights can be limited within the school building. Okay, so here's the background of the case. In December 1965, John and Mary Beth Tinker, sorry guys, John and Mary Beth Tinker and their friend Chris Eckert wore black armbands to school in Des Moines, Iowa to protest the war in Vietnam. School officials told them to remove the armbands, and when they refused, they were suspended. John was 15 from North High, Mary Beth 13 from Warren Harding Junior High, and Chris was 16 from Roosevelt High. With their parents, they sued the school district, claiming a violation of their First Amendment right of freedom of speech. The Supreme Court sided with the students and teachers. They don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. All right, so a couple things here. If we want to go ahead and fill out the worksheet as we go, what is the issue involved in the case is freedom of speech in school, teenagers' freedom of speech at school, and to some extent, my freedom of speech as a teacher, okay? Excuse me. So the issue is ultimately identifying, well, you don't lose that right completely. All right, so at what point do you lose that right to freedom of speech in the school building? Okay, and that's the issue that's going to be questioned and have to be ruled on by the Supreme Court. So the court said the court did not have, however, grant students an unlimited right to self-expression. It said First Amendment guarantees must be balanced against the school's need to keep order as long as an act of expression doesn't disrupt classwork or school activities or invade the rights of others is acceptable. So I'm just going to zoom in a little bit here so we can see this. So it's basically saying that as long as you do not disrupt classwork or school activities. All right, it says their deviation in this case, in 1960s, the case with these kids wearing the black armbands, their deviation consisted only in wearing on their sleeve a band of black cloth. The court said they caused discussion outside of the classrooms, but no interference with work and no disorder. Okay, so the court was ruling on this, saying, okay, as long as you're not disrupting the learning environment of the school, okay, you should be able to express your views, your opinions, okay? If you are disrupting the classwork and school activities from taking place, that's at the point where now the school district can intervene with said punishments. Okay, so this is a big deal because this sets the standards that school districts still follow today as far as how far can students go with their freedom of speech. So here's the impact. So this is the precedence, okay, the impact of the case. It says in 1986, applying the disruption test from the Tinker case, Supreme Court upheld the suspension of Matthew Frazier, a 17-year-old senior at Bethel High School in Tacoma, Washington, who gave a school speech containing sexual innuendos. The court said it is highly inappropriate function of public school education to prohibit the use of vulgar and offensive terms in public discourse. Lower courts have relied on Tinker and rulings on school attire, allowing nose rings and dyed hair, for example, but disallowing a t-shirt displaying the Confederate flag. All right, so what I want you guys to see here, and this is what school districts today do, they apply what they call the disruption test. Okay, so when a school district's going to change a rule, let's say, on what you can or can't wear. All right, let's use Joliet West, for example. When I first started teaching there 13 years ago now, at that time, over the course of a couple of years, there was a lot of activity going on in the city of Joliet, a lot of gang activity. There's a lot of people being killed. And what students were doing is they're wearing shirts to school, like homemade RIP shirts, rest in peace shirts. So our school district created a new rule that said you can't wear those. And how they did that, because a lot of students were like, oh, I'm just expressing my opinion, I'm expressing my view, my family member that was lost. Well, the school district applied the disruption test. While all that was going on, these kids were wearing these shirts to school, it would create fights and other things would take place in the school hallways. So by applying the disruption test, all the way back from this case in the 1960s, our school district in the 2000s was able to use Tinker versus Des Moines as a reason to implement that rule about what you can or can't wear. Okay, so the disruption test is used. I can't guarantee it, but I can probably, for most part, probably say that when the school district board meeting was going on, they probably used either the term disruption test or Tinker versus Des Moines actually came up in discussion on whether or not they had the right to tell students they could not wear those shirts anymore. Okay, so I'm going back to your worksheet. Go ahead and fill that out accordingly. We got the date. It was 19, was this one? It was particularly 1969. Okay, so 1969 was the date of the case. The amendment in question is their First Amendment right to freedom of speech. And then you can go ahead and answer the questions accordingly. All right. All right, if you want to pause it and fill out those questions, go ahead. I'm going to move on to New Jersey versus TLO. All right. The date of this case was a little later. This was 1985, New Jersey versus TLO. This is about your privacy rights at school. So the bottom line is your belongings can be searched, but not arbitrarily. So, think about, I know our school district doesn't do it as much, but for years they would do these random searches. They'd come into the school, into the classroom, the deans, the security, everyone would have to stand up, empty your bags on your desk. Kids would all go in the hallway, line up. They'd all be wanded. If you had anything in your bag or on your person, meaning in your pockets, that you weren't supposed to have, you could be punished for it. Okay, and those were random searches. And I remember when they used to do those more often, a lot of students would, kind of complain, saying this is an invasion of my privacy. This is a unreasonable search and seizure, which was perfect words to use. Okay, this is the case that ultimately would allow those types of searches to take place. Okay, so let's go through this case. The background, again, the date was 1985. The background, TLO, a 14-year-old freshman at Piscataway High School in New Jersey, was caught smoking in a school bathroom by a teacher. The principal questioned her and asked, go on the next page, to see her purse. Inside was a pack of cigarettes, rolling papers, and a small amount of marijuana. The police were called and Terry admitted to selling drugs at school. Her case went to trial and she was found guilty of possession of marijuana and placed on probation. Terry appealed her conviction, claiming that the search of her purse violated her Fourth Amendment protection against unreasonable search and seizure. Okay, so let's go to our worksheet. The date of the case, 1985. The amendment and right in question. The amendment is your Fourth Amendment right, which protects you from unreasonable search and seizure of your property. All right, so Supreme Court's ruling says this. Now, I should explain this with the first one. Remember when we went through the notes on the Supreme Court, when the Supreme Court makes a decision, they don't just say guilty, not guilty, and then come up with a punishment. Okay, that's not how the Supreme Court rules. Their rulings, it's majority minority ruling. All right, whoever, if there's more than the majority that vote yes in favor of the student or against the student, they don't just say we're in favor or against. They explain why they're in favor or against ruling in a certain way. And that explanation could be, it's like an essay, right? And they explain it so that other courts, the lower level courts, can now use that as a guide, all right, to how to make decisions on similar situations. Okay, so the ruling of the Supreme Court ruled in favor of the school, okay, saying they had the right to search them. The students have legitimate expectations of privacy. So you have privacy, kind of like speech, right? Up to what point? At what point can that right be limited? The court said, but that must be balanced with the school's responsibility for maintaining an environment in which learning can take place. The initial search of Terry's purse for cigarettes was reasonable. Why? Because the teacher saw the smoke, smelled the smoke, and she was coming out of the bathroom where the smoke was. So that was a reasonable reason to search her purse. Okay. The initial search for Terry's purse for cigarettes was reasonable, the court said, based on the teacher's report that she'd been smoking in the bathroom. The discovery of the rolling papers near the cigarettes in her purse created a reasonable suspicion that she possessed marijuana, the court said, which also justified that further exploration. So the court ruled that there was nothing wrong with the search that took place in this situation. TLO is a landmark case on search and seizure at school. Okay, so there's going to be some very key things here I want you guys to take away with. So here's the precedents. Basically, school officials may search a student's property if they have reasonable suspicion. Okay, so if it's on school property, it's up for reasonable suspicion if you're being thought that you were involved in doing some type of activity that you weren't supposed to. That includes stuff in your locker, in your backpack, on your person, your pockets. Technically, could even include the car in the parking lot if it's on school property. Okay, that a school rule has been broken. So if a school rule is reasonably thought to have been broken, they have that reasonable suspicion, or a student has committed or is in the process of committing a crime. These are called suspicion-based searches. Now, these are the tricky ones. There are also suspicion-less searches. So in other words, searches where they don't know if you did or not. We don't have reason to believe necessarily that you did it, all right? Or who did it. They don't know. They want to figure something out. In which everyone in a certain group is subject to a search at school. Now, the key thing to suspicionless searches and how schools do this, if this is the line right here, everyone in a certain group. So what's that group? I mean, that can be determined by the school. It's a suspicionless search when they used to come into the classroom. So the entire classroom is the group. As long as every person in the classroom is being searched without suspicion, that's fine. If they search every locker in upstairs G building or E building or something along those lines, right? They're not just searching one locker, they're searching all the lockers. They're searching multiple groups of people coming in to the school with the metal detectors. Those are suspicionless searches, but according to the Supreme Court, in a school building, those are considered okay as long as they're searching the entire group, okay? If you remember that Bill of Rights worksheet we did with the different scenarios, one of the scenarios on there was a kid wanting to be, I think I had it written as wanting to be on the soccer team and had to take a drug test, and he refused, right? So this is kind of how where this case would actually be used for that, okay? If they're going to drug test the entire team, that would be considered okay. If they're just picking one kid without any suspicion and they're going to search that one kid, that would not be considered okay according to this court case. Okay, so this Supreme Court case, TLO versus about the suspicionless searches and suspicion-based searches is a case that we still use in our schools today. Okay, so again, if you want to pause it, go ahead and fill out the two questions that go with this case. And then when you're done, go ahead and hit play, and I'll go through the third one that I'll go through today, Ingram versus Wright, and then I'll let you guys go through the rest on your own, and you should be able to understand what is expected. Okay? All right, the last one I want to go over with you guys is an interesting one because it has to do with school discipline. So kind of how far can a school district take their punishments? This was Ingram Wright, or Verse Wright, in 1977. So if you want to go to your document and put the case down was 1977. Issue of school discipline, and the bottom line is teachers can use corporal punishment if your locality allows it. Now, corporal punishment, a lot of students might not know what that word means, but ultimately it means physical punishment. That's why there's a picture of the paddle there. Okay. Now the background is here. James Ingram was a 14-year-old eighth grader at Drew Junior High in Miami. Was taken to the principal's office after a teacher accused him of being rowdy in a school auditorium. The principal decided to give him 5 swats with a paddle, but James said that hadn't done anything wrong and refused to be punished. He was subsequently held down while the principal gave him 20 swats. While corporal punishment was permitted in the school district, so this is 1977, it was allowed at that time to do this type of punishment, James suffered bruises that kept him out of school for 10 days, and he had to seek medical attention. James and his mother sued the principal and the other school officials, claiming the paddle violated his 8th Amendment protection against cruel and unusual punishment. All right, so let's go back to our worksheet. The amendment in question is the 8th Amendment, and the right that goes with that is your protection against cruel and unusual punishment. All right, so now the Supreme Court has to rule on this. So this is going to be maybe throw some of you guys off when you first hear this ruling. It says the Supreme Court ruled against James. Okay, now just listen real quick as I explain this. Remember, the Supreme Court's not ruling whether or not that principal was guilty or not guilty of a crime. Okay, because most of us would probably say that principal went way too far. You know, even if paddling was allowed at that time in that particular school, you know, paddling a kid to the point where he has to get medical attention is taking it too far, and there's probably a separate crime that would be looked at today. Okay, but the Supreme Court's not ruling on guilty or not guilty of a crime. They're ruling whether or not the school district has the right to punish kids with physical punishments like corporal punishments. So that's why the Supreme Court ruled against James. Now again, remember, they write it out. They explain their ruling. Why did we rule against James? Well, here's why. The court said that reasonable physical discipline at school does not violate the Constitution. The 8th Amendment, the justices said, was designed to protect convicted criminals from excessive punishment at the hands of the government, all right? Not school children who misbehave. So they're looking at the 8th Amendment as that's to protect us from the government coming down on us with unreasonable punishments, not necessarily school districts and the principals and teachers. The court, however, did direct teachers and principals to be cautious and use restraint when deciding whether to administer corporal punishment to students. Now, this is why it would be hard sometimes to be a Supreme Court judge, because I guarantee you, let's say all 9 of them at the time probably said this principal was in the wrong. He went way too far. However, they got to rule on what their opinion is on the Constitution, not based on what that person necessarily did, but how would the Constitution apply here? Okay, so that's, again, why they ruled against the kid and in favor of the school district. But saying you can't go this far, this principal went too far. The justices suggested the school officials consider the seriousness of a student's offense, the student's attitude and past behavior, the age and physical condition of the student, and the availability of a less severe but equally effective means of discipline. So here's the precedence. The court left the question of whether corporal punishment up to the states and local districts. All right, so think about that real quick. If you remember when we went through the Constitution, all right, the Bill of Rights, first 10 amendments, and we went through the powers of the federal versus state governments. When we talked about education, we said that the federal government was not given the power of education. So since they weren't given it, the 10th Amendment automatically leaves the power that the powers not listed in the Constitution with the states. All right, so Supreme Court judges look at this and they say, hey, it has to do with education. The federal government was not given the power over education. This is a state power. So that's why it says here the courts left the question of whether corporal punishment, to allow corporal punishment up to the states and the local districts ultimately, which traditionally set most education policies. 22 states, when this was written, currently permit corporal punishment in public schools, and 28 have banned the practice. Now, this has since been has changed. I'll show you the current map. So when this was written a handful of years ago, 22 states still allowed corporal punishment. Let me do a new share here. Here's the current map. All right, so those states in light blue do not allow corporal punishment in schools. This is from 2016. I haven't seen an updated one yet. So this is 4 years old. There might be a few states that have flipped from dark blue to light blue, but the dark blue states still do allow some form of physical punishment, corporal punishment in their schools. And if you look at the percents here, some of these schools, this is telling you that 57% of the schools in Mississippi, school districts in Mississippi use it. 53% in Arkansas use it. 51% in Alabama use it. So there's some states that use it fairly regularly, I guess. I don't know, to what extent. I doubt, it's something where you're, bruising a kid with a paddle, but some form of physical punishment. Maybe it's cleaning or something like that. All right. Whenever I cover this in class, I always tell students, remember one time at a Saturday detention, I had to clean up the bleachers after a Friday night football game. That was my punishment. Saturday detention, cleaning up the bleachers. And that was not a fun job to do. That might be considered corporal punishment today for all I know. Okay. Needless to say, that was the last time I wanted to have a Saturday detention because that sucked. It was for 3 tardies. All right. So that is what you guys need to do. If you guys can, let me go back to the worksheet one more time here. So I need you guys to go ahead and fill out the rest of the worksheet with the other court cases that have to deal with teenagers in high school. And when you're done, make sure you submit it. If you got any questions on any of these cases, feel free to reach out through Remind or shoot me an email.